Hey guys, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. So yeah, all kinds of stuff just dropped. Yeah, so this is all relating to, well, the first part I guess we're going to read is relating to the Blake Lively's trying to get a protective order for her communications with Taylor Swift. So we're going to read that letter first, but then we have a cross motion to compel because Blake Lively is not wanting to produce communications or documents relating to, WME and Sony. And there's like a whole bunch of other stuff in there. Liz Plank is listed in there in the requests. So we'll go through all that. Also, I noticed when I was skimming over this just now, her deposition is supposed to be on the 23rd. So that's kind of interesting. But we'll go through this really quickly. And then I got to get back to work. Give me one sec. Just want to make sure I don't miss anything. Some of this is redacted and some of this is under seal. So there's going to be some stuff we can't see, but that's to be expected. So, okay. Okay, so this is the letter in opposition to that motion for the protective order, because she does not want them to obtain her communications with Taylor Swift, which is some of what they're asking for in the next document we're going to look over. Let's see. We write in opposition to Blake Lively's motion for a protective order concerning her relevant communications with Taylor Swift. The Wayfarer parties also request an order compelling Ms. Lively to produce documents relating to A, her allegations of sexual harassment and retaliation, B, her communications with Ms. Swift, Sony, and WME concerning the same, and C, her claims for economic damages, which are responsive to certain requests for production. So not wanting to produce documents relating to your allegations of sexual harassment and retaliation, that's not really an option at this stage. What? Okay, well, let me just see the rest of this. Federal Rule of Civil Procedure 26B1 provides that parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense. Okay. Relevancy is to be construed broadly to encompass any matter that bears on or that reasonably could lead to other matters that could bear on any issue that is or may be in the case. I think sexual harassment allegations kind of apply, right? Ms. Lively is bound by her amended initial disclosures. She contends that Ms. Swift is not central to Ms. Lively's claims and that the only allegations that were ever remotely relevant to Ms. Swift were in the Wayfarer party's now dismissed complaint. Rule 26A1 requires parties to disclose the identity of each individual likely to have discoverable information, along with the subjects of that information, that the disclosing party may use to support its claims or defenses. The Wayfarer party's initial disclosures identified Taylor Swift as having percipient knowledge as to the facts and events alleged in the pleadings. In her amended initial disclosures served a week ago, Ms. Lively identified certain individuals who she believes have discoverable information about her claims. And Exhibit C, I think, might be under seal. According to Ms. Lively, and of course they've redacted a bunch of stuff here, Ms. Lively's counsel signed her amended initial disclosures, thereby certifying that the disclosures therein are complete and correct. Ms. Lively is required to produce her non-privileged communications with witnesses identified in her amended initial disclosures. In fact, Ms. Lively previously represented in her formal discovery responses that she, and then of course it's redacted. Ms. Lively has publicly stated that Ms. Swift was with her on this experience the whole time, all throughout it. She lived this with me. In her motion, Ms. Lively does not contend. I'm sorry, it's just really funny. She's like, this is totally irrelevant. And I love they say like she had nothing to do with any of this, but then Blake was out there the whole time just being like, oh my gosh, yes, she's been everywhere. Like which one is it? I think we know, but it is in fact Blake that dragged Taylor Swift into this, not Justin. In her motion, Ms. Lively does not contend that the production of her communications with Ms. Swift relating to It Ends With Us and this action is disproportional to the needs of the case. Okay. Ms. Lively's communications with Taylor Swift are also relevant to Ms. Lively's alleged garden variety emotional distress. So remember that she dismissed with prejudice her claims, or withdrew or dismissed, I don't know which one it is, her claims of intentional infliction of emotional distress and negligent infliction of emotional distress. That was done a done deal yesterday, I think. But she's still going to try to claim garden variety emotional distress, like, oh, I was so sad and anxious, and it was totally Justin's fault and not me because I, have to have total control over the film, like I've said in numerous interviews. All right. In Smith v. Pergola, the plaintiffs claimed that they suffered a significant loss of enjoyment, anxiety, and social withdrawal because of the defendant's alleged discriminatory conduct. This court granted the defendant's motion to compel the plaintiff's production of text messages and emails concerning their visits to social venues because they were relevant to the plaintiff's request for emotional distress damages. Specifically, the court held that communications and postings showing that plaintiffs experienced a great deal of pleasure and no anxiety while at these venues might go a long way to showing that any immediate impact that they suffered from the alleged discriminatory conduct did not have a lasting effect. Here, Ms. Lively recently withdrew her claims for intentional infliction of emotional distress and negligent infliction of emotional distress. Thereafter, she stated she still pleads and intends to introduce evidence of garden variety emotional distress in connection with her other remaining claims. As part of her remaining claims for harassment and retaliation, Ms. Lively alleges that she has suffered and continues to suffer from severe emotional distress and pain, humiliation, embarrassment, belittlement, frustration, and mental anguish. In an order dated June 10th, the court confirmed that the dismissal of the IED claims did not preclude Lively from offering evidence of garden variety emotional distress. If Ms. Lively and Ms. Swift socialized after the alleged incidents at issue in this case, as has been reported, and then they cite an article down here that said Taylor and Travis were on a double date with Blake and Ryan in October. Okay. As has been reported, the Wayfarer parties are entitled to relevant communications to disprove Ms. Lively's purported emotional distress. Ms. Lively's improper reliance on hearsay to shield production of relevant documents. Let's see. The crux of the motion is that because a Daily Mail reporter, and I think that was James Vituska, quoted an unidentified insider as stating that the Wayfarer parties obtained unspecified information from Ms. Swift, Ms. Lively should not be compelled to produce relevant communications with Ms. Swift in her own possession. Okay. So that's what they were arguing. But they basically said that Brian confirmed it, and they sort of misquoted intentionally, in my opinion, what was actually said, which was that an unidentified insider had confirmed this to the Daily Mail, which is quite often the case, that an unidentified insider confirmed this to the Daily Mail, which may or may not just be a Twitter post. All right. That's not a knock at Josh, just, Tellingly, it's not his article, of course it's not. Tellingly, Ms. Lively does not cite any legal authority for the proposition that such double hearsay is a proper basis to preclude the Wayfarer parties from obtaining relevant discovery from Ms. Lively, especially information which the Wayfarer parties believe will further exculpate them. Okay. In any event, counsel for the Wayfarer parties and Ms. Swift both confirmed that no communications between Ms. Lively and Ms. Swift have been provided to the Wayfarer parties. That acknowledgement, which Ms. Lively is unable to contest, refutes her contention that the discovery sought from her is cumulative and duplicative, and warrants denial of the motion. For good measure, even assuming the Wayfarer parties had received relevant documents from Ms. Swift, which they have not, such hypothetical fact does not relieve Ms. Lively from complying with her own obligations under Rule 34 to produce documents in her possession. Ms. Lively should be compelled to produce documents responsive to the other requests. Give me 1 sec here. Okay. It is undisputed that Ms. Lively is obligated to produce documents concerning A, her allegations of sexual harassment and retaliation, B, her communications with Sony, which released the film, and WME, her talent agency, concerning the same, and C, her claims for economic damages. Such documents were demanded on February 21st, 2025, and Ms. Lively formally responded to such demands on March 24th, almost 3 months ago. The parties' agreement to produce documents on a rolling basis does not entitle her to withhold relevant information that speaks to the heart of her allegations until the deadline for substantial completion of document discovery. We respectfully request the court deny the motion, the protective order motion, grant the cross motion, and direct Miss Lively to immediately produce documents responsive to the request within her possession. Although we appreciate the positive influence Miss Swift's music has had on her worldwide audience, God damn it. It was Miss Lively and not the Wayfarer parties that contemporaneously inserted Miss Swift into this dispute, and Miss Lively cannot use Miss Swift's stardom to withhold evidence. All right. Let's move on to this one. Okay, so this is a declaration of Kevin Fritz in opposition to the protective order motion and then supporting the cross motion to compel. Kevin Fritz is one of the Wayfarer party's attorneys. Let's see. Neither Miss Swift nor her counsel, I had to make sure I unmuted myself there, sorry. Neither Miss Swift nor her counsel have provided the Wayfarer parties with any communications between Miss Swift and Miss Lively. On May 22nd, Miss Swift's counsel notified Miss Lively's counsel that no communications had been provided to Wayfarer. Therefore, when Miss Lively's counsel demanded the same day at 4:57 p.m., so they were notified at 10:58 a.m. that Taylor Swift's counsel did not give the Wayfarer parties anything, document-wise. When Miss Lively's counsel demanded the same day at 4:57 p.m. that the Wayfarer parties produce documents obtained from Miss Swift or her counsel concerning Miss Lively's counsel already knew that no such documents were in the Wayfarer parties' possession. And they're still, trying to, okay, you know what? In an email delivered on June 12th, which was like last Thursday, I think, and in accordance with Rule 4C of the individual practices, I requested that Miss Lively's counsel meet and confer telephonically the following day at 3 p.m. about the requests, which includes request numbers 108 to 109, seeking Miss Lively's communications with Miss Swift relating to It Ends With Us, and the action, respectively. Hence the statement by Miss Lively's counsel in her declaration dated June 13th that the Wayfarer parties have still not made themselves available to meet and confer on this issue is inaccurate. In response to my email, Miss Lively's counsel confirmed on June 12th that they will be ready to discuss the parties' productions as needed on June 13th. Minutes before the scheduled meeting, Miss Lively filed her motion. Given Miss Lively's prior representations and her formal discovery responses, the motion was the first time that she advised the Wayfarer parties that she was refusing to produce documents responsive to requests 108 and 109. During the June 13th call, Miss Lively's counsel refused to discuss request number 108 to 109, which is Miss Lively's communications with Miss Swift about the film and the action, because moments earlier, Miss Lively had filed the motion. So they did that right before the phone call, so they wouldn't have to talk about that, I guess. When Miss Lively's counsel was reminded that I had requested, in accordance with the individual practices, that counsel meet and confer about the issue, Miss Lively's counsel again refused to discuss the issue and stated that I could oppose the motion. When I suggested that notwithstanding Miss Lively's premature filing of the motion, i.e. before the parties met and conferred, the parties should discuss requests number 108 to 109 to resolve the dispute and moot the motion, especially given the court's already busy docket, Miss Lively's counsel still refused to engage. Moreover, during the phone call, I explained to Miss Lively's counsel something they already knew. The Wayfarer parties are entitled to communications between Miss Lively and these non-parties identified in her amended initial disclosures as having discoverable information. The requests were included within the Wayfarer parties' first set of requests for production of documents and things to Lively, dated February 21st. Even though 10 weeks has passed, since she responded on March 25th, even though 10 weeks has passed and even though the parties agreed to make rolling document productions, Miss Lively has not produced any documents responsive to the requests. For the requests pertaining to Miss Lively's allegations of sexual harassment, her communications with Sony, which released the film, and WME, her talent agency, and documents concerning her alleged economic damages, her counsel refused to commit to a date for the production thereof and merely stated they would be produced prior to the July 1st deadline for substantial completion of document discovery. I also submit this declaration to place before the court true and correct copies of the following documents. Okay, it's a copy of the request for production, and then a copy of her responses and objections to that, her amended initial disclosures, a true and correct copy of an email chain spanning June 11th to 12th between counsel for Miss Lively and for the Wayfarer parties regarding the document requests and Miss Lively's failure to produce documents responsive thereto, and then a true and correct copy of the Wayfarer party's initial disclosure. Okay. I'm not going to read all of this, but we'll see. We'll go through some of it. This is just kind of like what they're asking her to produce. Kevin McKidd. Is that who I think it is? Why is Dr. Hunt involved in this? All right, hold on. Sorry, you guys probably couldn't see that very well. There we go. All right. So there's like some names in here that I recognize. Alex Sachs, Angie Giannetti, Ari Emanuel, obviously. Let's see. Emily Baldoni, Colleen Hoover, Brandon Sklenner, Jenny Slate, Isabella Ferrer, New York Times, Megan Toohey, that's obvious. And remember, some of this was like, it's not going to really apply anymore because some of their counterclaims were dismissed. Hold on, we're just going to skim down this. Robin Lively, of course, her sister, who was also on the film. I think she was like an extra or something. I can't remember. Adam Monshine was the guy who played the OBGYN. And she claims that she was like almost naked or had to be almost naked in that scene, but they, deny that, like that she was in shorts. And he's also like come out publicly and said, what the fuck are you talking about, basically. One sec. Okay. Sean Levy, Bradley Cooper, Liz Plank. There's Taylor Swift. I wonder why Jackie's in here. If you guys know who Jackie is, she did some editing, I think, for the film. Okay. So it's just listing everything that they are asking her to produce. So we're not going to read through all of that, but documents and communications relating to and reflecting your communications with Jenny Slate relating to the action. And then there's, of course, Isabella Ferrer. It's going to be just a lot of the same. Ryan Reynolds' communications with Greenberg. Dr. Leslie Dobson. Fuck that lady. Oh my God. I was just talking about her the other night. If you guys are like following the Laura Owens thing at all, this is the psychiatrist that had she's basically come out and said Justin was an abuser based on the most brain dead logic ever. And I'm like, as a forensic psychologist, you cannot come out and just say these things about somebody you've never met. It's completely unethical to like diagnose people the way that she does. Jesus. I mean, it's a mess, but she does it. So what is this in the Wallace case? Give me one sec. I'm always afraid I'm going to have accidentally muted myself when I'm just like going off on a tangent like that. Something just popped up here. I have to buy it on Pacer. I don't want to fucking do that right now. I'm going to. I just don't want to. Hold on, what? Oh, no. That's probably the emotional distress claims. It's got to be. Yeah, okay, so they're just notifying the court about that. Okay, we're going to go back to why we are here. So, like, some of this stuff, like I said, is probably not going to be really relevant anymore. All documents and communications relating to Cesspool and Deadpool and Wolverine, like, I don't know if that's really, at this point. Sorry, a lot of scrolling here, guys. I'm so confused as to why Jackie's on here. Okay. And then, of course, this part is redacted. Like, we can't see that. There's an unredacted version filed under seal. Same here with C. These are emails back and forth from last week. I mean, we've kind of seen them arguing back and forth about when the documents are going to be produced a lot, so I'm not going to go over that. But last week, they were all up in arms about they haven't done anything yet, even though they agreed that that would be done by Friday, and they were like complaining about it on Thursday. I'm like, you couldn't wait a day? Fuck. Okay. So here's where I saw about the deposition. Counselors were available to meet, confer at noon, 3 p.m. Eastern on Friday about the email concerning our document production and about Ezra Hudson's letter concerning Blake Lively's June 23rd, 2025 deposition. That is in less than a week. For the sake of expediency, please also be prepared to discuss Lively's woefully deficient document production. Even though we served our first set of requests for production months ago, and even though 10 weeks ago Lively assured us via her formal responses and objections that she would conduct a reasonable search for and produce relevant non-privileged documents, she has produced nothing other than documents that she obtained from her company, Van Zandt Incorporated. Oh, fuck, not this again. That's actually so funny. As merely a few examples, Lively has not produced documents and communications. The fucking, oh, Jesus. Lively has not produced documents and communications related to her allegations of sexual harassment and or other misconduct relating to the film. Documents and communications relating to or reflecting communications with Sony related to sexual harassment and or other misconduct, probably because there's fucking not any. Documents and communications relating to and or reflecting her communications with WME relating to sexual harassment and or other misconduct. Documents and communications relating to her claims for damages, such as those supporting her allegation in paragraph 457 that she has suffered and continues to suffer substantial damages. Okay. Documents and communications with Taylor Swift, who, according to Lively's amended initial disclosures, has knowledge of the party's alleged conduct, complaints, or discussions about the work environment or conduct on the set of the film, the production, editing, cut, and creative process associated with the film, publicity surrounding the film, the retaliation campaign alleged by Miss Lively, and resulting damages suffered. Will you put all that out there and then you're like, no, this isn't relevant? Fuck. That's dumb. Given that such documents and communications are material and relevant to the crux of Lively's claims, and given that more than 2 months have passed since Lively assured us that such documents would be produced, we intend to promptly raise this issue with the courts unless a mutually agreeable resolution is reached. Well, damn. Lively and reasonable don't belong in the same sentence. I mean, I'm not going to argue with that. Yeah, that's crazy, man. Plaintiff's initial disclosures. Okay. The Wayfarer parties make these disclosures subject to and without waiving, but on the contrary, expressly reserving any attorney-client or work product privileges or any other applicable privileges or immunities. Okay, so name, address, and phone number of individuals likely to have discoverable information. Of course, Justin Baldoni, these guys are all parties. Reese, an assistant to Mr. Heath. Okay. These are all parties. That's some like employees of Wayfarer. Ryan Reynolds. Leslie Sloan, Stephanie Jones. I mean, there's nothing super new here. Alex Sachs, a producer on the film. This was the Sony executive. Oh shit, I forgot Kevin McKidd was in the movie. He played the dad, that's right. But it was only in flashbacks. Also, I was like, why is this Grey's Anatomy guy in this document right now? Okay. Well, I'm not going to go through too much more of this. You guys will be able to read the whole thing if you want to, so. I got to get a quieter mouse. The above disclosure is based upon information known to date, and therefore the Wayfarer parties reserve their right to examine witnesses in depositions and at trial beyond the scope of these disclosures. Okay. Don't need to go through that right now. Yep, that's it. Okay. Can Blake's team get in trouble for filing like 5 times a day? I don't know. I don't think so. No, different Jackie. Different Jackie, guys. Not that Jackie. I don't think it's that Jackie. Different last name, at least. And if you guys haven't seen Andy's trailer, you definitely should. Do you think Lyman will step down? No, I don't. I don't see him doing that. Sorry, I'm just trying to figure out what's going on here. Okay, I'm going to link to Andy's trailer. If you haven't seen it yet, you definitely need to. And I think they're still filming for this thing. So if there's any other crew that wanted to talk to them, you definitely should. Yeah. Sorry, I'm posting it and I'll pin it right there if you want to watch that. And then also, let me show you. Last night, if you didn't watch last night, we had Cassidy actually come on and talk to us about some of the stuff she's been going over in her channel about the conflicts that she says that Judge Lyman has and why she feels like the Van Zandt subpoena was actually like an issue that there should be a remedy for and that kind of stuff. So let me show you real quick a link to that, and then also her channel, and then I got to get back to work. Give me one sec. I need to move my head. Hang on. Okay. This is actually from Omar's house. And then we were at his pool, but we haven't shared much related to that yet. We got to edit that shit. So Cassidy's channel is right here. If you go I'm just going to link to this post, man. If you go here, you can find it. And then also, this is Rachel who did that interview with Omar about the Baldoni judgment. And so if you want to go check her out too, we'll do that here. All right. Thanks, guys. Appreciate it. I got to get back to work, so I'll see you later.